Facing Penal Code 209, learn what prosecutors must prove.
Imagine facing life in prison without the possibility of parole. That's the reality when someone is convicted of aggravated kidnapping in California. While simple kidnapping is already an incredibly serious offense, aggravated kidnapping under Penal Code Section 209 takes it to an entirely different level. Today, I'm going to break down exactly what transforms a kidnapping into one of the harshest charges in the state, what prosecutors have to prove, what the penalties look like, and what kinds of defenses might be possible. Under California law, aggravated kidnapping is essentially kidnapping with an additional, highly serious criminal purpose. Penal Code Section 209 covers situations where a person kidnaps someone in order to commit another serious crime, like holding them for ransom or reward, extorting them, committing a robbery, or carrying out rape or other specified sex offenses. In other words, it's not just moving someone against their will, it's moving them with a specific dangerous intent in mind. To understand the difference, let's start with the basics. Simple kidnapping generally requires two key things: moving another person without their consent, and doing it through force or fear. But with aggravated kidnapping, the law demands more: that the kidnapping is done for one of these specific purposes. You might think of it as a layered crime. The first layer is the unlawful taking or movement of someone. The second layer is that you're doing it to rob them, to commit a sexual assault, to demand money, or to use them as leverage in some other serious way. That intent changes everything in the eyes of the law. And here's an important point. The prosecution has to prove that you had that specific intent at the time the kidnapping took place. They can't simply say, well, later on, you committed a robbery. The law requires proof that when you took the person, you already intended to commit that additional crime. Now, the penalties are where the reality of this charge really sinks in. If you're convicted under 209A or 209B, you could be looking at life in prison with the possibility of parole. But if the victim suffers bodily harm or is killed during the course of the kidnapping, the sentence escalates to life without the possibility of parole, meaning you would never be released. Every form of aggravated kidnapping is considered a strike under California's 3 strikes law, which can make future sentencing even harsher. And aggravated kidnapping doesn't always stand alone. There are related charges that can stack the deck against you. For example, Penal Code 209.5 covers kidnapping during a carjacking. That's also punishable by life with the possibility of parole. If the alleged kidnapping involves crossing state lines, federal charges can apply, bringing an entirely different set of penalties. And if there are multiple victims, each victim can result in a separate life sentence, sometimes ordered to run one after the other. There are also some high-profile cases that show just how seriously California treats aggravated kidnapping. In 1976, the Chowchilla kidnapping case made headlines when 26 school children and their bus driver were abducted and buried alive in an underground bunker as part of a ransom plot. The kidnappers were initially sentenced to life without parole. Then there's the case of J.C. Dugard, who was kidnapped at age 11 and held captive for 18 years. Her abductor received a sentence of 431 years to life. These examples are extreme, but they underline just how severe the consequences are and how aggressively prosecutors pursue these cases. Despite all of this, being accused of aggravated kidnapping does not mean a conviction is inevitable. There are legal defenses that can make a difference. One of the most common is challenging the prosecution's ability to prove specific intent. If the state can't show beyond a reasonable doubt that you intended to commit the additional crime at the time of the kidnapping, they can't convict you under Penal Code 209. Other defenses include arguing that the alleged victim consented, that there wasn't enough movement to qualify as kidnapping under the law, or that they've identified the wrong person altogether. Every defense is built on the unique facts of the case, and the earlier an attorney can start investigating, the stronger the defense strategy can be. Aggravated kidnapping is one of the most serious charges in California, carrying some of the longest and most life-altering sentences on the books. If you or someone you care about is facing this kind of accusation, the stakes could not be higher. You need to act quickly, understand your rights, and have an experienced defense team protecting your future. Call today to schedule a consultation. The sooner you get legal guidance, the more options you may have to fight the charges and protect your life moving forward. If you found this video helpful, don't forget to like, share, and subscribe, and drop a comment to let us know what legal topics you'd like us to cover next.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.